On 5th of August, President issues a proclamation. Then it is not sent to Rajya Sabha. Rajya Sabha sends a recommendation without on the same day. Then Rajya Sabha approves reorganization bill on the same day. Next day it goes to Lok Sabha on the same day it is approved. But these Constituent Assembly debate took place over several years. These are the men and women who are most brilliant that have ever been born in this country. We owe a permanent gratitude to them. And if we were to interpret Constitution as today's governments tell us, we'll be doing great disservice to these men and women. Please don't do that, Lord. They were much wiser than anybody in our generations. They knew what India's problems were. As Dr. Dhawan was at pains to point out, they knew about the diversity of this country. They felt the pain of every part of this country. And that pain they brought in various provisions to recognize this. It's not the article is not just a letter. It's the feelings of people of Jammu and Kashmir. Thus, by the instrument of accession, Maharaja took the very important step of recognizing the fact that his state was a part of dominion of India. So this is very important, my lord. The repeal does not subserve any purpose. Jammu and Kashmir is integral part of India.
Completely against you, Mr. Dave. Even para 5, it says should be held to be continuing in force.
Yes.
And then 6 and 7 says that the second submission based on 2 of Article 370 does not find support even from the language of that clause, which only refers to the concurrence given by the government of the state before the Constituent Assembly of Singhvi. And makes no mention at all of the completion of the work of the Constituent
Assembly. Does not find support even from language of that clause, which only refers to concurrence given by government before the Constituent Assembly was. That's what I'm submitting. No, that's a very limited. It's a temporary provision within a temporary provision.
But this seems to give seems to hold that the article in its entirety would continue to govern even after the Constituent Assembly had completed its task.
Lord, it can't be. You can't now resort to 373 to repeal it. Constituent Assembly has accepted. It's a one-time exercise. President acted upon it.
It is not repealed, Mr.
No, it becomes inoperative.
So from time to time, this is what I said earlier, time to time COs have been issued.
No, we are not on 371. I am on 370 subarticle 3.
Even the present exercise, other argument being open, it is not removed. It has applied the other provision. As it exists in the statute of the Constitution.
No, Lord, they have repealed it. They have deleted it. They have exercised 373 to delete it.
All provisions, now as it stands, is all provisions of this Constitution amended from time to time will apply.
Yes. But they have abrogated 370 and applied all the provisions of the Constitution. Both they have done. That part was not permissible.
So Dave, we can just go a little earlier. Paragraph 4.
Yes.
First argument and the second argument, that will clarify the situation.
It was left to the Constituent Assembly. Otherwise, it makes mockery of the provision. If now somebody else, complete stranger, were to decide, the governor will make a recommendation, or the president will make a recommendation, or parliament will resolve. Here what they have done is that parliament resolved. It's an unusual procedure. It's neither a constituent power nor a legislative power that parliament exercised on 5th and 6th of August 2019. Parliament resolves that president may issue an order under 373 abrogating it. It's an extraordinary I must say, legislative act, a parliamentary act. It's neither legislative nor constitutional. It's not a constituent power. Advice that because state is under president's rule, parliament therefore is constituent assembly or legislative assembly, and therefore this could be done. But it can't be, because that has come to an end. After a temporary statute has expired, no proceedings can be taken upon it as it ceases to have any further effect. 373 is that. 1949 FCR 595. I'm not going to trouble reading it. But this is a state, and this has been recognized subsequently. Even General Clauses Act doesn't apply, your lordship said, to temporary statutes. And Article 367 expressly begins with a non-obstant clause, subject to the contrary. Article 367 begins with the non-obstant clause, says subject to the contrary, unless context otherwise requires. Now, Lord, 370, therefore, context is completely different.
That does apply. Section 21 will apply, that what is said.
I am looking to the statute and making submission on, because federal court judgment was not granted. I'm sure you will get opportunity.
No, this judgment says that the General Clauses Act will apply it.
Yes, I have seen that, Lord. I have seen that. I have marked that portion also. But Lord, my respectful submission is that here, because of the context of 373, I respectfully submit that in respect of sub-article 3, there is no question that it should apply. Now, Lord, one judgment that I would like to place before your Lordships for consideration is, Lord, this is my second my argument that Lord 370, Lord, our sub-article 3 stood exhausted, and therefore President Lord neither could exercise powers nor could Parliament recommend to the President to exercise that power. Rather than enabling, facilitating full integration of erstwhile state of Jammu and Kashmir with rest of the country, which was neither in national interest nor in interest of state of Jammu and Kashmir, how impeding? Somebody makes a statement from Home Ministry, giving no detail as to how it has impeded. Law and order problem certainly exists, but it is not because of applicability or otherwise of the Constitution.
Mr. Dave, are you inviting the court to review the wisdom of the decision of the government on the abrogation of? So you're saying that judicial review should reassess the basis of the government's decision that it was not in the national interest to continue with Article 370.
Chief Justice Chandrchud said in A.K. Roy that not this theory that was developed in United States Supreme Court, that political decisions courts shouldn't go into. That is now, so that was given and in Podial, your Lordships expressly rejected that argument.
But judicial review would be confined to a constitutional violation. Constitutional violation, certainly it's amenable to judicial review.
But I would respectfully submit that even subject.
There's no doubt that if there's a constitutional violation, this court has a jurisdiction to review. Of course, that's undoubted.
Let me put it this way. President is undoubtedly exercising powers under 370, purportedly. In Samsher Singh, your Lordships have said that President can only exercise presidential power in constitutional sense. No other sense, not personal.
But the wisdom underlying the decision to abrogate.
There is no question of wisdom. President can only look at 370. President has to be advised by his advisors that 373 does not exist today.
Then we are back therefore to the constitutional argument. Constitutional argument, of course, judicial review was available, and we are addressing ourselves to that. There's no doubt about it.
Constitution. Your Lordships are right.
Fraud on the Constitution.
I am on fraud on Constitution that President is today exercising a power without any material whatsoever, without any justification whatsoever, and to wish it away by simply saying that it was impeding. But surely this court is not going to accept that kind of a very cavalier affidavit on part of Union of India. Argument was this, that these are political questions, don't go into it. Your Lordships had nothing doing, we will go into them. And now after Bomai, your Lordships have expanded the horizon. Your Lordships have gone to an extent, there can be no doubt.
The way, do we really need to labor on the counter? We have to interpret the constitutional provision as it stands. How is this relevant?
Your Lordships are right, I bow down. I am submitting that there are no reasons available in presidential exercise, nor are they given in counter. It's bereft of many reasons, the whole entire exercise. That's my respectful submission. Yes. Now see last sentence. There can be no doubt, therefore, Jammu and Kashmir became integral part of India, and Constituent Assembly, an elected body, had also given its imprimatur to the provisions of Constitution of India. Parliamentary recommendation, in my respectful submission, suffers from complete colorable exercise of parliamentary powers. It was neither exercising constituent power under 368 nor any legislative power. Resolutions are passed by Parliament on many issues, sometimes not even to honor some individuals or to say some other things or to recognize great events in the country. So Parliament here passes resolution and says, Mr. President, you kindly do this. that brought in my respectful submission is a pure act outside parliamentary broad powers. And they did it only because the assembly was dissolved, purporting to act as assembly of JNK. That we are now, since assembly is dissolved, therefore a president has the powers and parliament therefore has powers under 356. So Lord, whichever way one looks at it, but your lordships may look at the UP assembly case, or your lordships may look at Samshed Singh's case. If not the exercise of power by the constitution or by the parliament has to be done under the constitution itself and in the constitutional sense, then in my respectful submission, brought constitutional sense or constitutional provisions prohibited both the president and parliament from touching Article 370, sub-Article 3 in any manner to abrogate it. There is no power to abrogate 370 under 373 because as I respectfully submitted that it has lived its purpose, its object, and therefore it no longer is available for exercise. In any case, the exercise suffers from a fraud on the constitution because it has been done completely contrary to constitutional provision. And the principle of federalism, principle of democracy, which Bomai has so beautifully ascribed. Because ultimately, that's why constitutional framers were very conscious. Let the people of Jammu and Kashmir decide how they want their relationship. They decided for all times to come. It was not a temporary exercise by Constituent Assembly. That's why I said it would be travesty of justice that Constituent or Legislative Assembly of Jammu and Kashmir were now to be given authority to say that no, Constitution of India will not apply to us. That power also for them stands exhausted. So those are my respectful submissions. Therefore, I respectfully submit. There is one aspect which, yes, I must tell you. In my written submissions, I have quoted from the 2019 manifesto of the Bharatiya Janata Party. In that, they expressly said that we will work towards abrogating Article 370. But in my respectful submission, this court has already said in 2013 judgment that these manifestos can't be contrary to constitutional scheme. One, and directed EC to issue guidelines. 2015 EC issued guidelines and told all political parties that your manifestos must be within the constitutional scheme and spirit. Now, today, because you have majority in parliament, you have done not for any purpose. So, this argument of impeding, etc., is not relevant at all. It doesn't exist. The only reason you have done it because you told people of India to vote for you because I will go and abrogate Article 370. That shows that the power has been exercised for colorable considerations. The actual exercise is fraught with clearly I would say irrelevant considerations which cannot apply to constitutional exercise. The president is not a rubber stamp. He had to see this. Yes, you have the majority in parliament, but majority doesn't speak. It's not a constituent power. You didn't want to go therefore to the majority of both houses of parliament. You didn't want to do that. You didn't want to go to legislature because you are now taking away out of 5 Lok Sabha members and 4 Rajya Sabha members. Once you divide territory, those members, that representation is gone. If the representation is gone by virtue of Article 368(1), you are supposed to go to many state legislatures and take their approval because they are also concerned. 368 is very beautifully worded. There are so many safeguards in it.